Hello, this is Kathey Batey with Divorce Support Anonymous. Welcome. Welcome to Preparing for Mediation. The workbook is readily available to be emailed to you to help you as you go through this journey of divorce. It's the first step. It's preparing to see your attorney for the first time or preparing to go to mediation. I am not alone in this conversation, and joining me today is the esteemed attorney, Peter Letzmann, who has been through thousands of mediations, domestic, civil, and different sorts, civil rights as well. So we are going to tap into his expertise today as we go through this document, Preparing for Mediation. The whole purpose today is to get you empowered as you go through this process. You are in a territory you have never been in before. So we want to prepare you to see your attorney for the first time, to give you that information and those tools that are going to help guide you through this journey. The first step is seeing your attorney. So help me welcome, first of all, Peter Letzmann. Welcome, Peter.
Thank you, Kathey.
It's great to have you here. And a disclaimer, we are not going to give legal guidance, advice. We are going to give some legal information. So I appreciate your expertise here, Peter, in that when we get into some of these sticky questions, you'll be there to provide us some legal information. So I want to start today, before we get into the document itself, I want to start with, how do we find an attorney, a good divorce attorney?
Well, the first thing you have to do is figure out what kind of attorney do you need. And before you figure out what kind of an attorney you need, maybe you should figure out whether you need a divorce attorney, because not every divorce requires an attorney. There are some very simple, straightforward divorces that are uncontested, minimum amount of property, minimum amount of issues. And if the parties are willing to work with each other, the divorce, you can save a lot of money and do it quickly. There are a lot of self-help books available. In Michigan, we have a divorce, the Michigan divorce book that is available for purchase somewhere, Amazon or Barnes & Noble or your favorite bookstore. And it literally takes you through the steps that are necessary. And most of the books have forms that basically you fill in. So you could save, thousands of dollars by doing it yourself. You have to be careful, though, that you don't get in over your head. So caution, but be aware that that option is available. Now, if you're taking a look at getting an attorney, what type of an attorney do you really want, or what type do you need? And I think the first thing that you should think about is that you should have good chemistry with your attorney. Is it someone who speaks sort of your language? Is it someone who has some empathy? Someone that you respect, someone that you can trust, just all of the necessary elements, and including competence, but it goes to more than competence when you select your attorney. And the next thing I would ask, take a look at chemistry, and the next thing I would ask you to take a look at is the particular expertise or the niche that the attorney is practicing in. Is he a divorce attorney that specializes in divorces, in child custody cases, in large estates? Or is he a jack of all trades? And unfortunately, in many of the small towns there in Michigan and throughout the country, the attorney has to handle all sorts of cases, everything from probate to personal injury to estates. And you need someone, I would suggest, that specializes in divorces. And you may have to shop around for someone who's comfortable doing that. And we'll talk about competence a little bit later on. Is your case one that is a big financial case? Is there a lot of money involved? Are there houses? Or is it just the just sort of standard home and cars and retirement. And so you may not need that great expert. You may be able to settle for a person who is more of a middle of the roader type of attorney. Are there children involved? And is this attorney competent and used to handling cases that involve children and some of the specialty issues that involve children? And then the other thing that's I think is important is, do you need a bulldog? Is the spouse and or the spouse's attorney, are they one that would be willing to compromise? And then maybe you don't need to have that intimidating attorney, maybe, or maybe you need a combination of both, someone who could be a bulldog and someone who could be a negotiator. And then be aware, though, that attorneys, unfortunately, I'm an attorney, so unfortunately, attorneys are not cheap. You know, the typical divorce, at least in Michigan, $5,000 to $10,000 is not unusual. Yes, a little less. Many are more. I have seen attorney fees in the hundreds of thousands of dollars, much to the chagrin of the parties. But when it's a contested, ugly divorce, the attorney fees can add up real quickly.
Thank you. So where would one look? If you've never had any dealings with an attorney before, where would we begin in looking for an attorney?
Isn't that unfortunate that we have to live our life, probably half of our life, without having to deal with an attorney, but for the traffic ticket or maybe that automobile accident or so on? So where do you look for an attorney? The first thing I guess I would suggest to you is, do you have friends and family acquaintances who have dealt with a divorce attorney, somebody that knows the business, not just an attorney, but a divorce attorney? So check with your friends and family, not necessarily Joe the bartender, but check with people who have had actual experiences with an attorney. And then ask the professionals that you deal with, your tax accountant, your psychologists, your minister perhaps. And what I find is a good source of attorneys, not so much, well, you can find good attorneys by asking your insurance agent. Insurance agents deal with, disputes all the time, and they can steer you in the right direction as to where you may find an attorney. If you can't get this word of mouth going, if you live in a family that just hasn't had any disputes and there's no experience with attorneys, you can always check with the State Bar Association. They have a list of what they call domestic attorneys or matrimonial attorneys or people who deal with divorce. Now, the State Bar Association doesn't give you a rating or tells you this is a good guy or good gal or so on, but they'll give you a list. Get somebody in your neighborhood or within commuting distance. Don't get somebody who lives 300 miles or practices 300 miles away and has to charge you travel time. And take a look at, see if there's a friendly name that you can find there. The other source would be the local bar association. Most big cities most counties have a bar association of local attorneys. And likewise, they are by sections and look for a divorce attorney or an attorney who has dealt and experienced with divorces. Then I would ask you to, if you have this list of attorneys, take a look at the ratings that they have. There are various forms of ratings out there. Look for AV, that's Martindale Hubbell, that's the highest rating that they have. There's another firm, Thomson Reuters, that has the super lawyers. You may want to take a look at that. And then go on the internet and you will see the attorneys are rated. There are comments by people who have dealt with that attorney, and certainly 5-star attorneys are great, but look out for that 1-star or 2-star. Read those comments, see what the problem is that those individuals have had with the attorneys. So take a look and to pick out your attorneys. And don't be, yes, there will be some urgency, but don't be in a hurry. Don't select the first attorney that you talk to.
And most attorneys would allow you to have a conversation or a first meeting with them.
Indeed, in terms of picking an attorney, that that is very common in the practice of law. That an attorney will give you a initial consultation, typically about a half an hour, a little less, a little bit more, to discuss your case, and that is the time that the attorney has to demonstrate to you that he's competent, he has the experience, that he has the chemistry and all of those things. And that is the time that you ask him the question is, why are you competent? Why can you handle a case of this size with this problem with the children, with the difficulty that the husband has, to interview him and let him convince you that he is, or she, and I'm using the male gender, but it's neutral. Let him convince you that he's the person that you should hire. And take a look at training. Does he have the post-law school training in terms of belonging to the specialty sections of the state bar? Does he go to the updates, and does he stay up current with the law, or is he as smart? Was he as smart as he could be when he graduated from law school and never had any additional information or any additional updates since law school? So take a look at what education he has. Take a look at experience. Is he experienced? Has he tried? Ask him, how many divorce cases have you handled? How many divorce cases with kids have you handled? How many divorce cases have you handled where the money is more than $500,000 or $250,000? Or do you handle small cases that are less than $100,000? Get a little feel for his experience that he has. And then one of the other things, kind of a sleeper question, is does he have available to him the experts? And if you have a contested divorce, you're going to have to take a look at bringing in some experts to testify on your behalf. For example, an appraiser for the value of the house, an accountant to determine the value of a pension, perhaps. You know, those types of experts that you may have. A psychologist in terms of if there's a question with the children, and maybe a forensic accountant to see if there's any money that's being hidden under the mattress or so on, under the mattress speaking.
Right.
So take a look at those things when you are picking an attorney.
Those are really good tips. Now I want to get into preparing to see your attorney for the first time, and that's going to bring us into the book. But if you would speak to just a couple of tips for people to prepare to go for the first time to see your attorney, as you have the interview, but now there's also some homework that you can be doing that's going to save you a lot of money.
The key word here is the more preparation you do, the less attorney fees will be charged to you. So think about, if you want to save money, if you want to prepare so that you have an understanding of the case, that you get involved in the case. Preparation means saving money. Just kind of keep that in mind. So the first thing I would suggest, and before you see the attorney, get Kathey's book. And there's a lot of questions that you should have answered, whether it's the first time you see the attorney, whether it's shopping for the attorney. You should know what the status of the state of your divorce is. And the best way to find out is go through Kathey's book and take an inventory of those things that are in there. The second thing that I would suggest to you when you do finally select an attorney is steel yourself, because you will hear some things that you don't want to hear. You are convinced that this is the way that things should turn out, and anybody that looks at this fact situation would come to the same conclusion. Well, you're looking at it from your eyes. What would an objective person have, and what do you think the judge would have? So your attorney will be able to tell you his, again, experience, what the judges in your community will do, what the law is. And the law is not what you want it to be, what it is. So you may hear the word no, or we can't do that. And that's not the attorney's fault. That is not a competent attorney will tell you no. An incompetent attorney will tell you, well, we'll see what we can do, or so on. Competent attorney should know the law right from the get-go. So steel yourself a little bit and be prepared to discuss business issues. This now, if the divorce has been filed, it no longer is an emotional issue. And Kathey can talk about the emotional issues. I'm the cold-hearted attorney, and that's what we do, is we count the money, we divide the money. You get this asset, the other spouse gets that asset, and so on. And get yourself ready to separate the emotional, the feelings from the business decisions, the money decisions that you have. And then I think that other thing that you should be prepared for when you go see the attorney is typically there is a contract or what they call a retention agreement. And that spells out the terms and conditions of his service engagement. How much are you going to pay him? How much is he going to charge for an hour? Expert witnesses, court time versus research time. If he uses an intern or a law clerk, all of those things are spelled out. And you will be held to a contract. That's an enforceable contract. Even if you get an adverse decision by the judge and you don't like the decision, and you say, well, I'm not going to pay you because you didn't give me the results that I wanted, you're still going to be on the hook to pay that attorney, whether or not you got those results. So take a look at is the retainer refundable, or is that retainer just a down payment? And you may want to, depending upon how comfortable you are reading these agreements, like any other small print boilerplate agreement, take it home, read it. You don't have to, again, like I said, you don't have to do it. It's urgent, but you don't have to do it quickly. You can, and maybe there's somebody else in the family that has gone through the divorce who can help you navigate through that retention agreement. So at that point, I think you should be pretty comfortable in having the attorney that you can trust, you have confidence in, you have chemistry, and hopefully not get everything that you want out of the divorce, but get the things that you really need for yourself and for your children out of the divorce.
Thank you. That is critical information for all of you that are listening. I understand how overwhelming this can be just in this section, but stay with us because we are going to go through this workbook, and you are welcome to review this recording several times over. But it is important information, and that is something what has been stated by you, Peter Letzmann, should be taken to heart and understood, because it is going to empower you, it's going to help you. So now we want to go ahead and go into the mediation, Preparing for Mediation workbook. So this is the workbook that is going to be emailed to you upon request. There is not a cost to this. This is the first step as we go through this 6-month journey of support through divorce. So as was stated, how important it is that we get ready and preparing. So these words here, I'm going to skim through some of these pages, but there are some things that are important to note. For example, this is general information. If you do have a divorce that's quite complex, you may need that forensic accountant that Peter was mentioning, or other resources. That this workbook is not quite as in-depth as what you need. However, for most, 95% of them, this is going to be the document that you need to work through to get these papers gathered, the documentation gathered, put in one place, organized, and ready to go with it. Now, again, this workbook, what we are stating today is not legal advice, it is legal information. So I want to make sure that you are aware of that. You will need to check into this, to study this, to prepare for this.
Kathey, may I just interrupt for a second? In terms
Sure.
of, it's not that we don't want to give you all the information that you need for your divorce or your child custody or property settlement. Number one is we are in Michigan, and Michigan, like every state, has certain nuances and uniqueness to its particular law dealing with divorces. So what may be good in Michigan may not be good in Texas or in Virginia or so on. So it's state sensitive. And the other thing is that each case is a little bit different. And the attorney, in order to give you advice, not information, to give you advice, really has to know the background and all the nuances of your case. And for someone to sit down and talk to you for 5 minutes and tell you this is what we should do, that's information.
Yes.
To give you legal advice, there has to be an in-depth conversation to find out the nuances of your situation.
And
I just felt I had to explain that, Kathey.
Yes, thank you very much. And this is where you start that advice conversation with your attorney, is you walk in with these documents prepared and organized. So we want to just let you know, we're going to talk a little bit about a mediation, because the majority of you will have the option of mediation. A mediation is an opportunity to come together. I am a mediator. Peter is a mediator, where you come together with a third party and try to work through these disputes. What is so helpful about this is it gives you more power in your choices. So if you were to go through the court system, you would stand before the judge, he would review your information, and he would determine how your future is going to go. But in mediation, you are able to be more empowered and to negotiate back and forth how you would like to get this resolved. And we have, what would you say? I would say 98% of the mediations that I do, and Peter, probably you do, come to some resolution. Is that a fair number?
You know, it varies, but it's a very, very high. It's in the upper 90s for sure, because if people are prepared and understand what the purpose of the mediation is, they jump to it and they come to agreement in the mediation. They will much rather come to their own solution than have some guy or gal in a black robe who sees them for 15 minutes make that decision for them.
Absolutely. Couldn't agree more. So what do you expect in mediation? The first thing that's going to happen is a domestic violence screening, because when you go into mediation, you need to have a balance of power. If you are intimidated in your marriage, and this goes for women and for men, and not able to speak up for yourself, you may not be folks who can go through mediation, or we need some really special circumstances for this mediation to take place. So it's important to know, is there that balance of power? Can you speak up for yourself? So truly, truly important. So what's going to happen is, once it's determined you can go into mediation, what Peter and I do, and most mediators will do, is they will meet with you first to get a feel for what's going to be resolved during this mediation. So I'm going to sit down with you and I'm going to say, even though I may have received information from the attorneys, I'm going to say to you, tell me what it is that we are going to resolve today. And then I'm going to take a lot of notes throughout my time with you. And then once I have worked with you and I've worked with the other party, I'm going to bring you into a mediation room where you are going to sit across from the other party, from your soon-to-be former spouse. Beside you is going to be your attorney. The things that I want you to know here are, number one, this is not a pressure situation. No one is going to pressure you to make a decision. This is going to be an opportunity for you to negotiate, to discuss, to trade back and forth. And we want you, as was mentioned earlier from Peter, have your best business sense with you. This is, I know it's emotional, I know it's difficult. However, you are in a business transaction. And if you can get that mindset, it is helpful for you to realize that. So I have an opening statement. Let me see if I can bring that up as well, stopping this share. And I just want to just hit a couple of points on this, because I think it helps you to know what it is that you're going to go into. So this is actually what I use for my opening statement. Talk about my background. I say that I'm impartial. I say that I don't owe your attorneys any favors. And my role here is to be in charge of the process. I'm not going to advise you in any way, but I control the process. Sometimes that is redirecting the question if things get out of hand, or it's also encouraging the attorneys to speak and also telling them not to speak, because this is your mediation. This is totally confidential. And what happens with this confidentiality is it allows you to be creative. You can put things out on the table. What if this? What if that? And I, as a mediator, may encourage and put some things out on the table that have not been considered before. The great part about this is if it doesn't work, then no harm, no foul. But it also allows you to relax a little bit, negotiate a little bit, and to know that if you have to go into the court system, no one is going to say to you, but you said in mediation. It doesn't work that way. It's not admissible in the courts. It is a private, a confidential opportunity for you to work through these issues. Our goal here is to get that written agreement. Nothing counts. Nothing is legal unless we get that written agreement with both signatures on it. And you always have the opportunity to say, time out, I want to talk with my attorney. Time out, I want to go take a walk, get some air to think straight. We allow that for you because we want you to feel really confident when you are signing those agreements. So I'm not there to judge right or wrong, to give advice, and we want to deal in the facts as much as possible. And the second to the last statement there that I added a few years ago is, this is not a place to punish the other party. So you want to be as efficient as possible, keeping in mind you are paying your attorney, you are paying the mediator. In most cases, however, Peter and I both do some volunteer mediations through the Dispute Resolution Center, but there's a lot of money that is being spent right here. So you want this productive and you want to deal in the facts when you are going through it. So let's go ahead and go back to the document. Any final thoughts on that, Peter?
No, I just want to make sure that we cover the advantages of mediation, not only the essence of the mediation, but what really are, why people should at least try. Not only are we successful in avoiding courts 99% of the time, there are other benefits, Kathey, to mediation that the folks should know.
Absolutely. They are numerous, and I know we could spend this whole hour just talking about the benefits of mediation.
And the most important, I think, is it saves you money. Going to mediation in the long run will save you lots of dollars in terms of getting ready for trial. If a case goes to trial, a divorce trial, you talk another $5,000 or $10,000. So you want to avoid a trial if you possibly can. So think about the money and think about the relationship. If you go to court and there's a court decision, somebody comes out the loser, and people will be even more bitter than when they went into court for a mediation or for a trial. If you go to mediation and you work out, maybe that's the first step in learning how to deal with your ex-spouse in the future when there are problems in the divorce. And let me add just here, Kathey, that there are also post-divorce or post-divorce mediations where you may, the judgment may be final and there is still some issue that needs to be resolved, or an issue crops up in the future that may be mediated where you don't have to go back to court to resolve that problem.
Yes. And to your point, Peter, when you're in the mediation, your attorneys are there really to advise and protect you. But when they get into the courtroom, they are very adversarial. They are there to win. And it's a totally different dynamic. So you do want to take advantage of mediation for sure. Let me just speak quickly about your rights. When you go to mediation, again, you are not pressured. You do not have to sign anything. You may come out of there with a partial agreement, which happens sometimes, in that we could agree on all of these things, but we could not agree on the house, or we could not agree on the children. So if you have a partial agreement, all of those things are off the table. They're resolved. Now you only have to go to the court for that one item or one or two things that you could not come to an agreement on. So you have the right to stop a mediation at any time. And you have a right for timeout, and you will not be pressured in a mediation. So let's start with your network of experts. You need a support system through here. You may need a family coach. That could be a pastor, a therapist. You're certainly going to need a legal coach, which is going to be your attorney, and his or her team as well. A financial coach. Perhaps you need to consult with the person who does your taxes to understand some of the ramifications of what is proposed from the other side. You may need a parenting coach. So I want you just to think about who are those people, that network of experts that you can bring alongside of you to be of help. Now, it'd be great if you had a CPA on the financial, but maybe you'll have an uncle, someone who is very near and dear to you, who is very smart financially and able to guide you through what is a good common sense decision. So there's other contact people there that you may want to have on hand. Again, you're gathering all these documents, you're putting them all in one place, you're organizing them so you can feel more empowered in this process, because divorce doesn't give us a lot of power. In fact, we feel like it takes away a lot of our say and a lot of our power. But in having this information together, it is going to empower you.
Kathey, before you leave your support system, let me add that be careful of Joe the bartender. Be careful of your hunting buddies. Be careful of your shopping girlfriend or so on. They all want to be very, very supportive of you as you're going through this trauma of divorce, and they will be giving you answers that you want to hear. And the answers that you want to hear as you go through the divorce are not necessarily the facts, the truth, the legal statement. So be careful of what you choose or who you choose to get advice from. Make sure it's somebody who's credible, has the experience, has the knowledge to do that.
Great words, thank you. This is just really general information, where you work, what your income is, what last year's income was 2 years ago, an average, just to have your numbers at hand in case you're asked by this. Again, if you're in an attorney's office and you're sitting down and he or she says to you, okay, let's figure out what your average of the last 2 years were, or anything like that, you can say, here, I've got it. It's done. Therefore, you're saving time in that attorney's office and saving yourself money. So we're going to get some documentation together, and this is your checklist. You're going to bring in tax returns for the past 2 years. Now you may ask, why for the past 2 years? Because if someone was planning on going through a divorce, they have probably been preparing financially and in different ways. So we want to look back for 2 years to see if there was any disruption, anything that raises a red flag. So you want your tax return for the past 2 years. You want bank statements for the past 18 months or 2 years, charge card statements, retirement account statements, vehicle titles, get those together, property deeds, mortgage statements, appraisal of the marital home. So all of these documents are going to be necessary for you to meet with your attorney for the first time and to go into mediation. So you get all that documentation, you put it all in one place in a folder, and then you have it. And you can organize it however you want, but having this information is really important. So let's talk, and I want to ask you this on the appraisal as well, Peter. Many times people show up to mediation, they do not have an appraisal of the home, and so it's very frustrating because we can't work through the value of the home without an appraiser, unless, what are the chances that both of you and your soon-to-be former spouse can agree, okay, we both agree this home is worth X amount of dollars?
Yeah,
A word of caution that you want to make sure that that's truly what the market is saying. Peter?
yeah, if you don't know what the value of an asset is, a home or whatever, how can you divide that in half? If you don't know what it is? So it's incumbent upon the parties somehow to establish what the value, whether it's a home, a car, or so on. And if it's a home, Kathey already mentioned an appraiser. An appraiser could cost $400, $500, $600 and will be able to testify in court as to the value of the house. You may want to choose another way of doing it, a real estate market value survey, where the real estate agency just compares similar homes, similarly situated, with same number of bedrooms and garage and so on. It's a less accurate, but a fairly accurate way of doing that. And the other thing that you could do, and it fluctuates with time and conditions, are here in Michigan what we call the SEVs, the standard state equalized value of the home. And the SEV is 1/2 of the value. That's what they base the taxes on. But that's what the township or the local appraisers, the city, the municipal appraisers thinks your home is worth. Now it's a crude way of doing it, gives you an idea of what it's worth, but you can do that. So if you have any one of those 3 areas, it becomes easier to agree on the value of the home. And that's the starting point of this mediation system in terms of dividing the property.
Great, yes. And so you're going to want to put the home, the appraised value, again, what is the mortgage? Are there debts? Are there liens on the property? Maybe your Uncle Joe let you borrow $50,000 to do a remodel, and you still owe that back to Uncle Joe. So you want to make sure that you have that there listed. And you're going to look at the equity, which is after the bank's paid off and Uncle Joe's paid off, and that's the true value that you will be dividing.
Kathey, let me interrupt about Uncle Joe. Uncle Joe's an important person in this transaction. If Uncle Joe expects to be paid, or you think you really need to pay back and it was not considered a gift, you should have it in writing. There should be an IOU, some sort of a documentation that you can show to the court that indeed there was a loan, and it may not be a recorded deed lien on the property, but have some documentation to support that allegation of that loan. Matter of fact, anything dealing with the house should be written.
Yes, thank you. Personal property. Now, Peter and I have both been through mediations to where they want to go through and list every single item. You get the salt, pepper shaker, I get the cream pitcher, whatever. Just a word of caution. Many times, well, not many times, but sometimes people will pay $10,000 in attorney fees for an item that's valued at $5,000. So you just want to be careful. I know that each of you are going to have those particular valuables, those items in the home that you want. You should know what those are going into this situation. Whoever keeps the home is probably going to keep the salt and pepper shaker, but have noted that which you really do want to keep.
Kathey, I a couple thoughts about the personal property. Number one is take a look, what has sentimental value to you? Your grandfather's hunting rifle. It may not be worth a whole lot, but at least identify those things. Grandmother's tea set, you know, that may have some photographs. Those things that have your wedding dress, or, you know, identify those. They may not have necessarily financial value, but sentimental value. So have that listing of those items for sure. And then in terms of the things that are just stuff, remember, yeah, you can split it, and that probably is the best way of dividing the property. But if you can't split it, the judge will make you sell it. And if you sell the property, it's going to be a garage sale or an estate sale where you're going to get 1/10 or 15% of the value of the property. So if it behooves you again to see if you cannot come to agreement at mediation on how you divide the property.
Great, thank you. Checking and savings accounts information. You want to have those account numbers. You want to have the balance as of the divorce file date. You want to make note, again, you're going back 2 years, 18 months to 2 years. You want to make note, were there some opportunity, or were there some times when some mischievousness was going on, that all of a sudden there's $5,000 withdrawn from this account that you didn't know about. So you do want to make note of those items. And that's why in this workbook, there is opportunity for notes. But you want all of that information. And if there are accounts that you do not have access to, then that should be during the discovery process when your attorney is asking the other attorney, or you're requesting from your soon-to-be former spouse that information for those accounts. They do need to be disclosed. So during the discovery process is when the attorneys, both parties, are exchanging information, so we know everything's out on the table. So
Kathy, let me just go back in terms of the checking savings accounts and so on. You mentioned that the date of the divorce or the date of filing of the divorce. Sometimes the separation date or the move out date is the critical date when you establish sort of separate maintenance. So if that's the situation, start keeping track, closer track. And what Kathey says about going back 18 months, 24 months should disclose that. Especially during the divorce time, keep meticulous notes of how and where the money is being spent.
thank you. Yeah, great information, Peter. Thank you. Credit cards as well. You're going to want, what are those credit cards? You're going to want that history to look at it, to find out, is there anything there that you have question of? That you can research and find that, or are there things that we're buying, selling, hiding? So look through these. And I know, folks, how easy right now you're probably like, oh my word, I'm so overwhelmed. That's the nice part of this recording. You can come back to it and you can review it when you are ready to deal with that topic. So again, you're going to get this workbook. I'm going to email it to you. You're going to have it. And you'll also have this recording to walk alongside of you. But you do want that credit card information, debt listed there. You also want, oh, I've got a noisy phone here, sorry. You also want to consider any other miscellaneous marital debt that you're aware of. Maybe once again, Uncle Joe's out there that needs to be paid back, that is marital debt. Retirement account information, you want that as well. Every asset, every debt is going to be debt to be considered and looked at in the mediation process. So what are those retirement accounts that you have? They need to be listed. Looking again, since you have 2 years or 18 months, the notes of withdrawals, closing or misuse, and you do want to have that documentation. Now, the value of when it's going to be considered is something that can be negotiated, because especially right now, the market has gone a little crazy. The retirement accounts have gone a little crazy. So that's something to consider, to get maybe your financial person's advice on, or perhaps your attorney's advice on. When would be the best time to put the line in the sand and split the value of these retirement accounts? Other thoughts on that, Peter?
Yes, and it's a broader thought than just the retirement accounts. Is the marital estate, the retirement account that is subject to be divided, is the amount of money that is in the account that has been earned or saved or gathered or so on during the terms of the marriage. If the spouse was contributing to that account prior to the marriage, and let's say at the date of the marriage, the account had $10,000, was worth $10,000, and during the marriage, they accumulated $90,000, the marital estate is just the $90,000. That first $10,000 is segregated or kept out of the marital estate. And likewise, if there's a home that, or property, real property that was acquired prior to the marriage and has been kept separate from the marriage, it has not been commingled, or other assets that have not been commingled, they may not be part of the marital estate. And your attorney can help you identify those things which are legitimately part of the marital estate and those things which are legitimately not part of the marital estate. You know, if grandmother left you the cottage in Northport, and you've always had that as a separate cottage, and you've only used it, you paid the taxes on it and so on, the husband may not be entitled to that. But again, that's state specific, and talk to your attorney about marital estate.
Thank you. So what can happen is, if you have retirement accounts, they can be divided 50%. And what would happen is a quadro, which is something called a quadro. One of those words you've never heard of before and will never hear of again, but necessary in mediation and in divorce. So what happens is you have the opportunity to roll those funds over into your own personal or private individual retirement account. So that can happen as well. But keep in mind, a lot of times in mediation, people say, oh, I just don't want my, excuse me, my retirement account touched. Well, then you have some negotiation there. Perhaps you want to give them more equity in the home to have that same dollar amount reserved and kept untouched in your retirement account. So this is a good time to speak to your CPA or whoever does your finances, and also consult with your attorney, because you were able to get that 50%, but perhaps that's not a priority for you. So it's negotiable. Cars, we're going to look at the value. What are those vehicles that you have? The boats, the motorcycles, whatever they are. What's the value of them? How did you determine? Was it by Blue Book? And if you have those titles with you, you can sign them over at mediation, get that paperwork done. So know the value, because typically people will keep their own, each other's valuable, but if one's driving a Lexus and the other one's I don't know, a Ford Focus, then there's a real discrepancy in those two vehicles. So you may want to just know what those values are.
Just like your home or the property value, bring the documentation. If you have a Blue Book or an Edmunds or whoever, make a copy of that printout and bring that to mediation with you.
Great words. Okay, so now, as if that isn't complex enough, now we're going to get into the part with the children, and this is minor children we are talking about, 18 and above, typically, depending on if your 18-year-old is still in high school, would not be considered, but as far as custody goes and as far as child support goes. So you want to put down the birth dates. Obviously, you know the gender, you don't need to put that down. But again, I'm just wanting to be real thorough. This is a document you also could hand over to your attorney. So you want to have that information on there. So there are two things, legal custody and physical custody. Sometimes friend of the court has already resolved this when you go into mediation. Some counties require that that's resolved first and taken care of. So there's some different comments here. And child support, you may be wondering, how is that figured? There is actually an application that you plug in all the different numbers, and it kind of spits out what that child custody would look like, what the dollar amount is. That is still somewhat negotiable, but it's a guideline that the court certainly does recognize. So you want to determine that child support, they're going to look at how many overnights the child is spending with you and the other parent, and also what's not on this version, it is on the one that I will send to you, is the income discrepancy of both parents will be taken into consideration as well. So bring that documentation, all that you need together to mediation. And we want what's best for your children. I know that my heart's grieved many times, Peter's as well, when you come into a mediation and parents are using the children as pawns to either hurt the other party or not have to pay child support. And trust me when I say research has shown that if you can get along with your soon-to-be former spouse, your children are going to benefit greatly. If you continue fighting in front of your children and bickering and talking against your former spouse to your children, you are hurting them in great depth. So another reason why it's important to get a support group, so you can process all of that there. And then when you step into being a parent, you can be a parent full on. So you're going to want to look at who's going to provide the insurance for the children. How are you going to divide?
Before you leave that, let me just emphasize how important it is for you to put that emotional element aside when you are dealing with things that involve the children, whether it's medical or support or extracurricular activities. Kathey says in the positive that it will help your children survive this trauma of divorce if you can cooperate. And I don't want to be the wet blanket or so on, but I do deal with some children post-divorce, and I have direct correlation where kids have threatened or have cut themselves or caused themselves harm because they are looking for some love from their parents that they're not getting. There are just so many negative, the juvenile courts are full of kids who are the product of rotten divorces. Don't send your kids to juvenile court.
Thank you. Can't emphasize it enough how important it is. And that's also why you want to get everything resolved at mediation, so there's not any unsettled things out there. So well, here's our guideline. And something else to note is if you come to this agreement and you resolve all of this, and then you both decide later, you know what, maybe I want to see my children more than every other weekend, or whatever the court said. If you two can agree on the best interests of the children, then you can do that. But if things go awry and you can't get along, then you go back to what the friend of the court or the courts have ordered. So keep that in mind. You're not stuck with it unless you cannot get along. So you'll want to look through here and look at those things that need to be resolved. The health insurance extracurricular, that's always a huge thing because a lot of kids are in sports and they're expensive. So other disciplines, beliefs, or programs that need to be discussed, put that down, have this in this workbook when you go to mediation. This is just a sample of a schedule. I like to see it visually. Some people have different ways of writing it, but I like to see it physically. So I can see where are they in the morning, where are they at night, where are they sleeping overnight. This is just a sample, and this is school year. Summer's going to be different. And then if you want to mark, there's an activity in there, a sports activity, you're going to put an asterisk and you're going to list who's going to be responsible for that. Again, notes down there. The more you can work out here, the easier it's going to be. You're going to want to look at holidays, breaks. How do we want those to be? Yes.
Before you leave that previous page, you mentioned the school year. This year has brought us to a time period where we were not in school. It was the school year, but we were not in school. And typically, and I fault myself for it, I write my agreements saying when school is in session, we will do this, and when school is not in session, we will do that. Well, we have to change our terminology. It's so that it's very clear that if we are under these conditions that we have with this, what is it?
Pandemic.
Sequester in place, that this will happen, and these are conditions. You don't think it's going to happen. We don't hope it never happens again, but we should write our divorce decrees in a way that those possible events, those contingencies are taken care of.
Yeah, good point. Very good point. So we do want to work through the holidays and decide where the children want to be, and split those up: Christmas vacation, spring, summer, any miscellaneous issues for the children not yet stated. Maybe you have a special needs child or a special therapy that your child needs to go through or is currently going through. We want to list those. We want to discuss them, get them all written out so that there's no question on them. So taxes, how are you going to file taxes? Which is going to benefit you better? Again, you're going to ask your tax professional on that. And who's going to claim the children? This is important to deal with this now in mediation. So again, there's not potential for future argument in the future. Spousal support in Michigan, it's not typical unless you've been married more than 10 years. And I don't know how that varies in other states. But if you've been a stay-at-home parent while raising the children and your spouse has been working all this time, therefore you're at a disadvantage in the work world, you may want to request spousal support. Okay, so this is just, if you're wanting to get things pretty much 50-50, this is just a document to allow you to write things out. Again, noting what's most important to you. What are you ambivalent about? There are some things that if I keep it, great. If I don't, that's okay too. It's easy to replace. So you want to know that. And this is just kind of giving you an opportunity to go through those things and regard which ones are going to be of help to you. I do have also, let me share something a little different. Here it is. That just really is a simple form. This is what I want to keep, this is what I don't care about, and this is what I don't want. So what's nice about this is that you are prepared, because it's a difficult day in mediation. Emotionally, it's confusing. You're going to be forgetful. So you want to have this prepared ahead of time. These are the things that are most important to me to keep. These are the things that I really don't care about. And these are the things that I don't want. The previous document is more if you want, okay, I want to split things valued 50-50, and you want to go through that work, that tedious work of doing that, you can do that. But there's a shortcut to do it. So here is this document, and you can kind of calculate over here, well, I've got $5,000 here, and so it's minus $5,000, so we can make up that $5,000 for him or her later, you know, just depending on, have a system that works for you. This is just another version. Again, you're not going to get everything you want. You're going to go in with this list and say, I really want this. And then in the middle of it, he decides, or he or she decides on something that really throws a curveball. So just be flexible, know what's important to you, take those breaks, the timeouts, get the fresh air, talk with your attorney, and work through these items. And then, of course, again, you're not going to get everything that you want. What's the second best idea? It's called a BATNA. What's the best alternative to having what I really want to keep here? And so at the end, you're going to have a list of those things that you have agreed on and those things that maybe were not resolved. So you will want to have those listed there. So this is actually, there's some terms that you may want to know, you may need to know. There's Quadro, as stated earlier. But this is the workbook, and I created it to be something simple so that it would not be overwhelming, but it is a beautiful, empowering start when you have all of this together and you go into your attorney's office for the first time, or you go to mediation having all of this organized. You know where to find it, you are empowered, you are ready to negotiate, and you feel like, okay, I'm going to put on my best business hat, my business sense, and we are going to go through this, and we're going to get it resolved, and no judge is going to tell me how the rest of my life is going to go. I'm going to work through this. I'm going to negotiate really smart, and I'm going to get this resolved so I can move on with my life. Any further comments, Peter Letzmann?
Yes. Don't be intimidated by the court, or don't be intimidated by the attorneys or your attorney. Attorneys are here to offer you services, and you compare the attorneys and find the one that suits you best. And you don't have to take the first attorney you talk to. Compare all of those elements that we have discussed in the past. And just let me remind you, re-emphasize, repeat, obviously I'm trying to make a point, is to separate the business of divorce from the emotion of divorce. Go to your attorney to talk about the business of divorce. Go to your groups, go to your therapists, go to your counselors and so on about the emotion of divorce. And I think with the information that Kathey has given you, you will be able to perhaps not thrive through the divorce, but at least you will survive the divorce.
Great words to end this on. You will get through this. It's a step at a time. Get that network of experts, get your homework, get all of your documentation together, get ready. You can do this, and we will see you next time as we journey through the difficult, traumatic journey of divorce. Thank you for joining us today. Thank you, Peter Letzmann, for all of your very valuable information.